Hello, my name is Eric Sapp. I'm a staff attorney at Legal Services for Prisoners with Children. LSPC is a legal support center. We provide uh, trainings, manuals, technical assistance, and advocacy support for qualified legal services providers throughout the state of California and other organizations doing legal aid. Uh, our orientation is for the furtherance of human rights of formerly incarcerated persons, presently incarcerated persons, their family, friends, and communities, persons with arrest and conviction records. Our mission is to expand and protect civil rights and human rights for persons in any of these categories in terms of their access to justice, their reentry into the community, employment rights, housing rights, conditions of confinement, as well as enfranchisement. And that's what I'm going to talk about today is one aspect of voting rights, and that's specifically the voting rights of persons in jail in the state of California. This will be a pretty brief video. I will make my email address available at the end for anyone who has questions or feedback. And there will be another video to accompany this, which will be a live session on the voting rights of formerly incarcerated persons in California. This particular on-demand video that you're watching now is specifically focused toward the forms of incarceration in jail and their implications for voting eligibility in California. The way this talk is going to run is I'm going to begin by discussing the topic of misinformation and voter education. Then I'm going to talk about the constitutional rights of eligible voters in jail contexts. Then I'm going to run through some of the statutes that relate to the same topic. Then I'm going to talk about some reform efforts that are pending or attempted and defeated related to expanding voter registration and access to voter turnout in jails. And lastly, I'm going to conclude with some reflections on the relation between the concepts of voting rights and voter outreach and get out the vote efforts. So if any of these topics don't appeal to you, just stay tuned because some of that will be interesting to you. So misinformation is the dissemination of false information, irrespective of whether there is any intent to deceive. It could just be innocently mistaken as to facts or inadequately but non-culpably failure to ascertain proper evidence for the claims being disseminated in contradistinction from disinformation. Now, I've shared an image from a Wall Street Journal segment from the 2020 elections, which was describing the danger of misinformation spreading through social media at the time of those elections. And that same Wall Street Journal piece about misinformation went so far as to give its own sort of meta conspiracy theory of how conspiracy theorists would be spreading misinformation about anything from the vulnerability of systems to attacks and misinformation related to the COVID epidemic at the time in efforts to suppress the election. Flash forward to 2022, and you have here a news report from CBS Face the Nation about disinformation, intentional manipulation, intentionally misleading information to influence election outcomes. Here, a reporter is describing how, quote unquote, the Russian playbook creates chaos and discord. This is a major security threat associated with the election system. Now, the two examples that I've given are a few years old, but they are representative of things you'll hear and read about today. Quite often, how hostile actors or foreign adversaries or foreign governments that the US government regards as an adversary are going to interfere in the election and compromise the security of results. Now, it is by no means my desire to contest the reality of election interference or to minimize the security threats that do face election systems in the US today. But I think it's also important to say that the bulk of misinformation that we see on the ground is not a result of bad actors, but rather the failure of good actors, so to speak, to adequately educate the public about voting rights. And it's no surprise that there is misinformation because the complexity of the election laws and the subtlety of some of the distinctions that are built into the election laws mean that even the experts are not always entirely clear about the eligibility rules. Indeed, some of the most dedicated and well-meaning experts may be not educating the public in the correct manner. So, for example, the California Secretary of State's website, as of the first week of October in 2024, has inaccurate and misleading information in its outreach materials for persons impacted by the criminal justice system. On your screen, if you have video, you will see a flyer distributed by the California Secretary of State called Voting Rights Restored, subtitled Persons with a Prior Felony Conviction. And this is also in print form, distributed by various local registrars of voting. And it contains a mixture of helpful, accurate information and inaccurate information. So it starts off noting correctly the various general criteria. Obviously, if you're a US citizen and resident of the state of California, 18 years old, not found mentally incompetent by a court, and not currently serving a state or federal prison term for the conviction of a felony. Now, it's this last point, in the way that they further specify, that becomes problematic. This is correct, but because it's not always obvious to someone whether they themselves are serving a prison term or how the courts understand the concept of prison term or how the statutes define it, it can be problematic. So, for example, the rest of this flyer says, if you meet these requirements, you can vote even if you, and then it has bullet points, have a misdemeanor conviction, and then in parentheses, a misdemeanor will never prevent you from voting, are on parole or probation, are on post-release community supervision, PRCS. Now, and that's the only bullet points that they further specify. So the natural way of reading that clarification, I think, for a reader not otherwise steeped in election law, would be the suggestion that felony convictions do not qualify as eligible. That is to say, someone with a felony conviction is not going to be eligible because it specifically singles out a misdemeanor conviction and says that will never prevent you from voting. Now, again, it is true to say that a misdemeanor does not prevent you from voting, but there's this additional category of, or a few different categories of felony convictions that will still be eligible for voting. And this flyer does not at all make that clear. In other words, if someone has a felony conviction but is not currently serving a prison term, they remain eligible. But that, again, does not come out clearly on this flyer. We'll look at what another flyer, based on older content from the Secretary of State's office, that is still also available. We'll see how that treats the matter in a moment. But first, I'm going to show you the Spanish version of this particular flyer. In fact, there are many languages of this flyer. So there's the version Restauración de los Derechos de Voto, and you'll see it describes una sentencia por delito grave en una prisión estatal ni federal, and then talks about delito menor, but again, it doesn't clarify the intermediate problem or set of problems, which is felony convictions not served in a prison term currently. Now, here is a slightly older flyer produced, I believe, around, or at least its basic content existed at least as of the 2022 elections. And this one is accurate. But the problem is, and this one is, in fact, still to be found on the Secretary of State's website, but you are more likely to encounter the one I just showed you, the Voting Rights Restored one, which is misleading. And I'll say in a moment why the other one is misleading, even though the point seems to be a subtle and fine one. So here it makes clear that you may be eligible if you are in a local detention facility serving a felony jail sentence. That's the key point that the other flyer misses, and that is precisely the matter on which most people have difficulty determining their eligibility or the eligibility of persons they're associated with. And that's an especially important category because in the wake of what's known as realignment in the early 2010s, a lot of felony punishments, which would, prior to realignment, have been sentenced to prison terms, were under Penal Code 1170H made into sentences to jail terms, even though they were felony convictions. And persons in that class of incarceration status retain their eligibility to vote, and that was made clear by a law which passed in 2016 or thereabouts, which I will get to in a moment. But now to continue with this flyer. So this longer flyer makes clear that in a local detention facility, if someone is serving a misdemeanor sentence, a felony jail sentence, if jail time is a condition of probation, whether it's misdemeanor or felony probation, or in a pretrial detention, that person is eligible to vote if they otherwise meet the criteria of age, citizenship, etc. Similarly, if someone is on probation, on parole, on mandatory supervision, on PRCS, federal supervised release, or a person with a juvenile wardship adjudication, they are eligible to vote if they otherwise meet the criteria. Now, on page 2 of this longer flyer, it then notes that one is unable to vote for the conviction of felony imprisoned in state prison, federal prison, or a local detention facility pursuant to Penal Code Section 2910 arrangement. Now, it would be helpful if the Secretary of State's flyers and maybe other informational reports made clearer the distinction between Penal Code 2910 arrangements and jail sentences for felonies pursuant to 1170H, because that distinction is one that is absolutely critical. In the case of a 2910 agreement, the person has been sentenced to a prison term. That is, the sentence from the judge was to a prison term, but for logistical housing reasons, CDCR, the California Department of Corrections and Rehabilitation, makes an arrangement with a local government, county or city jails, to house persons who would otherwise be lawfully held in the state prison in a local facility. Those persons are still considered to be serving a state prison term, even though they're not physically in state prison. And because they are deemed to be serving a prison term, they are ineligible to vote pursuant to the state constitution and statutes of election law. Contrast the 2910 scenario with the 1170H scenario, where someone gets a felony jail sentence. When someone is sentenced to a jail sentence for a felony pursuant to 1170H realignment sentencing, that person remains eligible to vote. So this second flyer does get it right. It could be clearer because, again, the distinction between those two types of incarceration in jail for a felony can be difficult to understand. And as a factual matter, a lot of the persons to whom it applies may or may not know what their actual situation is. And so clarity, I think greater transparency, both from CDCR and from local detention facilities about the exact status of arrangements that exist would be useful. And of course, better efforts to educate people inside about their rights would also be useful. And I'll get to some of the efforts along those lines later on in this presentation. So the second longer flyer, titled Derecho al Voto, has in the left-hand column the reference to una condena de prisión por un delito grave, specifying first that it's in un centro de detención local. So that's a felony jail sentence. And then it goes on page 2 also to describe the section 2910 scenario affecting un centro de detención local. And so this version of the flyer also gets it right. But again, whether the readers of these flyers are able to understand the distinction between these two types of scenarios of being incarcerated in jail, and which of them applies to a given person scenario is another question entirely. Now for the California Constitution. So Article 2 of the California Constitution deals with voting rights, and there are two key sections of that which govern eligibility of voters. So Article 2, Section 2, which appears on the screen, says as follows. Subdivision A, a United States citizen 18 years of age and resident in this state may vote. B, an elector disqualified from voting while serving a state or prison or federal prison term as described in Section 4 shall have their right to vote restored upon the completion of their prison term. This section was amended in 2020 by Proposition 17, approved by the voters. Now, Section 4, in turn, says the legislature shall prohibit improper practices that affect elections and shall provide for the disqualification of electors while mentally incompetent or serving a state or federal prison term for the conviction of a felony. That section also was amended by Prop 17 in 2020, which removed a prohibition on voting by those on parole. So prior to Prop 17, in addition to a prison term, being on parole was also disqualified. Prop 17 removed the parole disqualification. Now someone who's on parole can vote. And the constitutional language, again, requires the legislature to implement this through election laws that will disqualify someone who is, in the constitutional language, quote, serving a state or federal prison term for the conviction of a felony. Now, in the election code, that mandate for the legislature to regulate election eligibility of voters appears in Election Code Section 2101, which I've shared on the video screen, and I will read it out as follows. 2101A, a person entitled to register to vote shall be a United States citizen, a resident of California, not imprisoned for the conviction of a felony, and at least 18 years of age at the time of the next election. I'll pause there. So you'll notice that here it doesn't exactly track the language of the Constitution in subdivision A of the statute, but then subdivision C of the statute specifies it in ways that tracks the constitutional language. Subdivision B of 2101 says a person entitled to pre-register to vote in an election shall be a United States citizen, resident of California, not in prison for the conviction of a felony, and at least 16 years of age. Again, someone can pre-register at 16, but they can only vote when they're 18. Subdivision C, and this is important, subdivision C of Election Code Section 2101 says as follows. For purposes of this section, the following definitions apply. 1, imprisoned means currently serving a state or federal prison term. Notice prison term is the constitutional language. And 2, conviction does not include a juvenile adjudication made pursuant to Section 203 of the Welfare and Institutions Code. Section 2101 has, especially in the key provision applying to eligibility for or ineligibility for those serving a state or federal prison term, and eligibility of those who otherwise meet the criteria who are not serving such a term. That section has the form that it does today as a result of 2 bills passed in the past decade. One is AB 2466 of 2016, which I alluded to earlier in this talk. And the other is AB 646, which was a companion bill to Prop 17 in 2020. Now, this is especially the first of those, AB 2466, is especially worth noting due to the irony, and that ties back in with my point earlier about the well-meaning actors promoting election misinformation, because the current Secretary of State was the legislative author of that bill back in 2016, which passed through the legislature and was approved by the governor. So AB 2466 clarified the definition of imprisonment as follows. The relevant portion of the bill AB 2466 of 2016 is shown on your screen. It's a little different than 2101 as it exists today because um, uh, the renumbering and also the use of prison sentence rather than prison term. But what AB 2466 did that's relevant is that it made the definition of imprisoned um, say at that time imprisoned means currently serving a state or federal prison sentence. 2020's Assembly Bill 646, again, as a companion to Prop 17, or companion to what was then ACA 6 that became Prop 17, which was ultimately passed. That companion bill, aligned the statutory language to the new constitutional language of prison term, and it had eliminated the parole disqualifications. And you may notice that the numbering and lettering is a little different because in the meantime, the pre-registration regime had been implemented or introduced into law. And that brings us to what 2101 looks like today. Now, having the right to vote and having the protections surrounding eligibility on the books is an important aspect of the problem. The law does matter, but in practice, a lot of people in jail find it difficult to vote. Either logistical obstacles stand in the way, or lack of information about eligibility can also stand in the way. Some of the more common obstacles faced by persons in jail who are eligible to vote are the following. Not receiving their ballot, even if they're registered. That can happen in a number of ways, ranging from not being distributed through the mail process, which is maybe, if that occurs, should definitely be subject to a formal grievance. Someone might be registered on the outside and the ballot gets sent to their home address. And if they haven't changed the mailing address to that of the jail that they're in, they will find it difficult to get that ballot. So a person who intends to return to a prior home address, let's say in San Diego, who happens to be incarcerated in San Mateo, should have their home address for purposes of residency purpose and purposes of local elections still be the San Diego address, but their mailing address should be changed to the jail in which they're located to ensure that the ballot gets to them. Now, because people are in and out of jails and sometimes unpredictably, the process of changing the mailing address or having mail sent to a home address forwarded to one can take time and can cause someone to, possibly miss their chance to vote. Now, a lot of people who are in jail are homeless, which is to say that they don't have a permanent residence to return to and maybe didn't have one when they went in. Someone who's homeless or unhoused should put down as their address some location that they frequent, which could even be a street intersection, and that will establish their residency and also put them in the proper precinct for purposes of local election matters. And if someone who's unhoused is incarcerated in jail, their mailing address on their registration or re-registration should reflect the mailing address as the jail. One of the rights and powers that persons on the outside are able to take advantage of, which persons incarcerated are not, is the process of conditional voting or conditional registration and casting a provisional ballot. Now, in principle, someone in jail can do this, but the logistics and timing of it can mean that as a practical matter, it's not really possible to do that. So if you're not incarcerated, you can do same-day voting by going to a voting center. Same-day registration and voting by going to a voting center, registering conditionally, subject to verification, casting a provisional ballot, which, assuming the verification is successful, will be counted. And it will just be counted normally as if one had already been registered by the normal registration deadline and had cast a ordinary ballot. Now, the normal registration deadline is 15 days before the election. So for the November 2024 election occurring on November 5th, the registration deadline is October 21st. But after October 21st, as I said, one can do a conditional provisional process. Provisional voting is outlined in Election Code Section 14.310 and some other sections of the Elections Code. Because the process involves it requires the involvement of election officials. It's something that adds an extra layer of logistical difficulty for someone who's incarcerated in jail, so that someone who's in jail can't go to an outside voting center. They could request a few days earlier from the elections office a provisional ballot, conditional registration, but it takes time to have those things delivered. The likelihood that they're going to be able to get a delivery and pickup of such provisional ballots on election day itself is, in many localities, unlikely to occur. And therefore, the person who's in jail, as a practical matter, is not enjoying the same right to vote that someone who is not incarcerated is enjoying on or around election day, namely the ability to conditionally register and provisionally vote. Which is not to say that it hasn't been done. I mean, there are stories of intrepid election officials personally delivering and picking up conditional ballots, but it's not something that's guaranteed. Now, some efforts to correct that were put forward in a legislative bill, AB 544, which passed both houses this past term, but was vetoed by the governor. And I'm going to take a quick look at AB 544, which, though it's not the law, nevertheless shows some of the legal issues that remain to be addressed, and that future either legislative or administrative efforts might attempt to alleviate. AB 544, in its ultimate version, which passed both houses, would have created a grant program for 3 selected counties to run a pilot program during the period 2026 to 2028. So it would not have applied to this upcoming election. And those counties were San Benito, San Mateo, and Santa Cruz. And what it would require them to do in order to receive that grant funding, and what the funding would go to, would be to create in-person voting for all eligible incarcerated persons at each jail facility in the county, permitting an eligible incarcerated person to do any of the following: 1, return or vote and return the voters' vote by mail ballot; 2, register to vote, update the voters' voter registration, and vote pursuant to Section 2170. Section 2170 of the Election Code currently is the conditional voter registration provision. 3, receive and vote a provisional ballot pursuant to Section 14310. That's the provisional ballot section mentioned earlier. And 4, receive a replacement ballot upon verification that the county election official has not received a ballot for the same election from the voter. If the county elections official is unable to determine if they have received a ballot for the same election from the voter, county election official may issue a provisional ballot. The provision that I want to call attention to is, or the 2 provisions are the ones that enable conditional registration and provisional balloting. But additionally, what would be required at these in-person centers in the jails is also vote a regular, provisional, or replacement ballot using accessible voting machine that provides for private and independent voting experience. Essentially creating a in-jail voting center, which has been, there already has been pilot programs in LA County, which have been fairly successful. And some other things exist in Chicago. But those programs are not the subject of this. Again, I want to speak about what the requirements of AB 544 would have made possible in terms of provisional voting. Although the bill passed, it was vetoed on September 22nd by the governor, who explained basically that fiscal budgeting issues for the reason for the veto. The irony perhaps being that the original version of the bill was not the creation of a grant program, but rather, or let's say the first substantive version of the bill, which was the second version of the bill, went through several amendments from 2023 to 2024, created the mandates for in-person voting processes, but wasn't specifically a grant program, although pursuant to the Constitution, state mandates under some circumstances require support for localities that are burdened thereby. But it wasn't specifically designed originally to be a grant program. That was part of a long set of compromises, which both changed the timeline to push it out to 2026, pared it back from all localities in the state only to 3 pilot programs, and transformed what would have been a permanent program into a temporary pilot program. But one can, seriously question whether we should be, if indeed this program is protecting fundamental rights of voters, whether it should be simply treated as a spending package that is just a question of economics. However, something that the governor says in that brief veto message is very true, and that is, quote, counties are able to establish these types of programs without statutory authority. And by implication, what he also means is without funding provided by the state, but rather using existing county resources, either through raising funds to dedicate to the program, or just by reallocating existing funds, since it's not clear whether providing the voting centers in a jail necessarily requires an inordinate expenditure of money outside what the counties already do in the provision of voting facilities, combined with what the sheriffs already do in security and inside their carceral facilities. There are lots of places where that serve as, places that have other civic functions like churches or schools, etc., that have smaller, ordinary populations than a jail might have, and the security logistics are often overblown when sheriffs say that it's too difficult to do these things, as places like LA and Chicago have shown to be quite popular. So I promised a few words about the relation of voting rights and voting outreach, and I'm just going to be very brief as this video has gone a little bit longer than I had anticipated. So when we talk about the right to vote, I think of that strictly as a right which someone has a claim to exercise or to not exercise as they choose. The key determinant as to whether one has voting rights is not whether one votes or not, but whether one can vote if one wants to, and whether one is able to make an informed choice as to whether they want to vote or not by having accurate information about eligibility and about the consequences of voting and the processes that voting are a part of the broader civic and political processes. That being said, actual turnout can be a metric that can sort of indicate whether people have meaningful ability to exercise their voting rights, or whether obstacles are in the way. Some counties do a much better job than others in terms of the percentage of eligible voters that are registered and that ultimately turn out and vote. San Francisco County has relatively higher numbers than a lot of other counties in the state, and that is due probably in no small part to the fact that they have a dedicated office within the sheriff's department, their legal services office, which is tasked with the registration and voting facilitation within the jails administered by San Francisco County, and they get a higher percentage of voter turnout than neighboring counties in the Bay Area, for example. AB 544, or a similar type of program implemented today, which any county could, on its own initiative, institute the kind of processes that AB 544 would have obligated its grant recipients to do for a specified period of time. Those types of programs may not be a panacea, but they would at least remove certain types of obstacles and objections to the claim that voting rights are respected in jail facilities for all eligible voters. In a system that aspires to be democratic, and although the original constitutional design of the United States was not a democracy, nevertheless, the political culture nowadays is a democratic one by and large. And so the political legitimacy of our law and governmental systems should be assessed, at least in part, in terms of democratic norms. The um, political participation of citizens is a fundamental principle of democratic legitimacy, and if persons are excluded from exercising their political rights, to that extent, the legitimacy of the system is called into question. The legitimacy of the law applied to legal subjects is a function of those subjects also being ultimately authors of that law through democratic processes. In the ancient Greek conception of democracy, the citizens participated, and elections didn't have the function. There wasn't elections serving as the function of choosing representatives, but rather representatives were chosen by lot from the entire citizen population. Therefore, any person, any ordinary person, could be called upon to fulfill the duties of a legislator. Now, modern representative democratic systems don't have that degree of, let's say, faith in the demos. They are not democratic directly in that way, though they do have the advantage over the ancient system of eliminating the categorical exclusions that abounded in the ancient system. For example, the exclusion of women, and in the Greek system, categories like slavery, which existed. Now, the extent to which forms of enslavement exist in our current U.S. system on account of the 13th Amendment and equivalent state constitutional provisions is a topic for another occasion. But whether we're talking about direct democracy or representative democracy, the theory of democratic legitimacy is as follows. A law imposing duties, burdens, liabilities, and constraints on subjects is democratically legitimate to the extent that those subjects have a fair say within a fair say in the process whereby laws are enacted, maintained, and revised. If any class of persons subject to the law is systematically excluded from those political processes, to that extent, the law with respect to them is lacking in legitimacy. Now, incarcerated persons are among those most affected by the law. Indeed, someone who is incarcerated in a jail is subject to the total institution of control over their person and their way of living. Therefore, so this argument would go, the democratic legitimacy of such a law is questionable if the person subject to it the most have no say whatsoever in its application or the possibility of revising the laws that govern those institutions. So if one wants to claim that the carceral system administering punishments in enforcement of the criminal law in this country is legitimate and meets basic democratic criteria, it should be the case that even persons who are convicted of crimes and sentenced to incarceration should have the vote. Otherwise, the law as applied to them is not grounded in a democratic rule of law, but is simply a rule of force. That being said, the right to vote is not the same necessarily as a duty to vote. There are some countries where it's mandatory to vote for citizens, and they can, for example, be fined if they choose not to, or have other civil consequences. but that's not the case in the United States, and so there is no duty to vote. So someone can have the right to vote, and indeed value that right, but choose not to exercise it. And given the uh, uh, given the experience of many persons who are incarcerated um, unjustly, or under conditions which lack in fairness and equality and equity as between different social groups, a lack of faith in the system is to some extent justified. And under no circumstances should someone choosing not to exercise their vote be a basis for shaming them. Rather, um, what advocates should do is ensure that the right to vote is protected, and the knowledge and wherewithal of how to exercise it are made available to those who possess that right. And what they choose to do with it in terms of exercising the right is their choice. I'll end there. My email is available on your screen. It's erics@prisonerswithchildren.org. Feel free to send me any questions and comments or criticisms. Thank you.